Mr. Sanjeev Sharma talk about how policy is likely to evolve. Let me just begin with Mr. Sunil Gupta. So you have been part of administration for quite some time. How do you see the policy response happening to BEPS? In particular, do you really believe that BEPS is a vindication of India's position? How do you see negotiations of bilateral treaties going forward? What administrative measures do you think are going to come about?
Dinesh, BEPS, am I audible? Yeah, okay, thank you. Let's go into the background of BEPS. I think a number of speakers have spoken. BEPS project was taken up by G20 countries in the wake of global financial crisis. And the global financial crisis was considered was mainly due to lack of international laws and regulations. And taxation was one of the agenda where the G20 wanted international laws and regulations to put in place. That was the background of G20. And it is the mainly developed countries who were concerned about the base erosion. It was primarily dealing with preferential tax regimes. Now in the BEPS project, this has been expanded and taken to a much larger scale. Actually, the concern was shifting of profits to no or nil tax jurisdictions. But anyway, now the OECD has come out with 15 action points. There, again, I would say most of the measures are alignment of OECD Model Convention to the UN Model Convention. And India already follows UN Model Convention in most of its tax treaties. Just to give an example, the Action 1, the digital economy. The digital economy, the recommendation is that warehouse should be treated as a PE. That is a place of business from where regular deliveries of goods are made, should be treated as a PE, and this was not considered auxiliary and preliminary activity. This position India has taken in many of its treaties. Maybe now India may amend its remaining treaties to include this. Similarly, in the agency PE, where an agent habitually concludes contracts and in substance negotiates the contract, should be treated an agency PE. India has this position in many of its treaties. Transfer pricing, the AMP expenses, allocation of risk, where the functions are performed, that has been India's position all along. So to that extent, I don't see major change in India's tax position. However, this has resulted into an uncertain atmosphere for industries. From industry's point of view, if I see uncertainties in future. The 15 action points, what is the way forward for the government? The government should come out clearly how they are going to implement the best practices, the minimum standards, and what are the timelines? Are they going to implement this interest deduction, hybrid entity, CFC rules? Because for industry wants to know what is going to be the India's tax policy in future. As an MNE, Indian MNE would like to go abroad and invest. The India is now in a position to invest overseas. We should know what is our position in India. So, therefore, the government should eliminate this uncertainty in the business environment. Thank you. Dinesh.
Okay, thank you. So you are seeing basically Indian MNCs getting increasingly impacted because they just don't know what is their own situation in the home country. And the sooner we have the regulations, whether it is on transfer pricing or otherwise, you feel better off will be. That's interesting. Ajay, if I could just come to you. We are talking about multilateral instruments. We today have issues with regard to Mauritius, Singapore, limitation of benefit being potentially introduced in the India-Mauritius treaty. How do you see this entire interplay on a going forward basis? Sorry. Ajay, you heard me, right, as you walked in? So Ajay, what I was wanting to ask you was that we have this issue going on under India-Mauritius treaty. We are talking about possible introduction of limitation of benefit, etc. We now have the BEPS proposal. We are talking about multilateral instrument. How do you see the interplay between all of this?
As I see it, and what Mohan mentioned in the morning session, it will depend on what we ultimately legislate. I think the courts will be guided by the text of either our law or the text of the treaty. So BEPS, yes, is like moral policing till the time it is actually implemented as part of our legislation. And I would think that when Mohan referred to the two judgments of the tribunals, if you analyze the two judgments, in one, the court discarded BEPS where it was unfavorable to the taxpayer, and where BEPS had recommended that there should be no adjustment on location savings, the court used it to reinforce their decision that there can be no adjustment on location savings. So as I see it, that until this becomes part of law, and law which can be enforced in the form of either part of our domestic legislation or part of changes in the treaty, till that time, I would think this will be a hotly contested issue. That's how I see it. And for the past, certainly, you cannot, use BEPS to say that the intermediate holding structures that you had in Mauritius or otherwise, they are no-go.
We will come to that separately. Thank you, Ajay. Rohan, you heard Mohan Parasaran speak about judiciary. How will the judiciary react on a going forward basis? How do you see the impact of the BEPS recommendations on judicial decisions which have come thus far? And do you really see a change happen as we go forward? And or would the same principles continue to apply?
Thanks, Dinesh. So firstly, I think this is a unique opportunity for India to probably become the fountainhead of judicial precedents in taxation worldwide. We are, without a doubt, the most prolific deciders of tax cases in the world. And, this might actually be our opportunity for the world to outsource this to us. The situation quite clearly is, let's look at what courts are likely to do. As was rightly said, the overarching principle is that legislation is paramount in our country, and therefore, depending on how our legislature effectively takes these sets of provisions and places them in our domestic law, that will be definitive of how our courts will look at it, and quite honestly, it will be definitive of how we ourselves need to comply. Now, there are a series of areas, your CFC, thin capitalization, transfer pricing, etc., where how we effectively legislate will then be the law for us. Our courts will undoubtedly give primacy to our legislation and will interpret accordingly. Mohan mentioned that, it is his sense that maybe the courts will sort of have a hands-off attitude. I think given what we have in terms of history, both of legislation and in certain instances of tax administration, as also the mindset of the Indian assessee, I don't think courts will come out of the equation. I think courts will continue to remain a very important part of the equation. And to the extent that, both at the end of the assessee and the tax department, there is a lot of litigation which is taken forwards, I do believe that, we will, in fact, lay down the jurisdiction, the jurisprudence on this, really for the rest of the world to follow. So I don't think our courts will stay off. I think our courts like to participate. I think our courts have had a taste of deciding important economic matters, and I continue to believe that they will do that. So I sincerely do believe that while our legislation needs to be consonant with what is already set out in the BEPS, the administration is then the next issue in terms of whether we will have disputes or whether we will not have disputes. And if we have disputes, given the whole dispute settlement mechanism, waiting for a map and waiting for various other things, effectively take a lot of time. And the question is, what do you do between the point in time a controversy arises and you get a decision in the map? And in that period of time, you can't really say that I will pay the maximum tax. So I think courts will have a role, and I'm almost certain that we will be the leaders in this stream of jurisprudence.
So two things coming thus far. One, sir, the repeated assertion that the legislative framework needs to happen sooner